You don't need a fancy lawyer in a $3,000 suit to write a contract. You can ruin your life on a paper napkin for free. The truth is that contract law is very simple, and you unknowingly make contracts every day. Let's say two guys meet up at a bar. After they both had a few beers, Greg starts bragging about his new Lamborghini. He cashed in his cryptocurrency stocks and is arrogant. Greg laughs and says, "I'd sell this to you for $500 right now, just to prove I can buy another one tomorrow." Michael challenges him. "Bet you don't have the balls to put that in writing." Michael grabs a paper napkin and writes, "I, Greg Johnson, sell my 2026 Lamborghini to Michael Thompson for $500. Greg signs it, thinking he is just flexing. Michael signed it too. Michael takes the paper napkin and puts it in his pocket. They both continue to drink for a few more hours. As they were about to leave, Greg hears a ding notification on his phone. Michael just sent him a Cash App for $500 with the word Lambo in the notes section. Greg's face scrunches up and he says, "Hey, I was just joking." Michael says, "Too late. It's mine, bro." So, is a napkin contract legal? Yep. A judge doesn't care if the contract is written on a paper napkin. Instead, a judge only looks for 3 specific things. First, you need an offer. Greg offered to sell Michael his Lamborghini. Second, you need acceptance. Michael accepted Greg's offer. Third requirement is consideration. In contract law, consideration doesn't mean being nice to each other. Instead, it means there was something of value exchanged, such as money. The judge also won't care about Greg's secret intention for it to be a joke, because his words and actions will be judged by what appeared to be an obvious intention to agree. Even if you don't have the agreement in writing, there are other ways to prove a contract exists, such as text messages and emails, invoices, checks, or bank transfers, voicemail, Zoom recordings, or chat logs, witnesses who heard the agreement or saw it acted upon, course of conduct, which means did the parties act like the deal existed. So if you're negotiating and you aren't 100% ready to commit, don't put it in writing and never use definitive words. Never say "I will." Never say "deal." Never say "agreed." Instead, use words like "I might be interested" or "let me think about it." If you're curious about Greg's next legal defense to get out of the contract, watch the video in the description. But before you do, please like and subscribe.